Well, my script was being revised at the last minute. Some of you may have heard this already. I'm Charlie Corey-Wright. I'm Joint Head of Chambers. I'm introducing this seminar on the practical implications of capacity in personal injury claims and on the Court of Protection. You will be hearing from Derek O'Sullivan, King's Counsel. A standout silk elicits stellar market praise. That's Chambers and Partners. He's a band one personal injury silk. He's leading silk and legal 500. He is has a particular expertise in brain injury cases, including Farah and Abdullah Hai. The sort of thing you can't say about yourself that you can say if someone else is talking before you. So I hope that's informative. Arianna, who will be speaking to the Court of Protection side of things, is described in Legal 500 as having star quality. Is a superb advocate. She's a leading junior in Chambers and Partners, and is also all types of Court of Protection matters. She acts in those. She's worked extensively in community care with an outstanding knowledge of the Care Act. Derek's talk is going to cover all things capacity from a personal injury perspective. Arianna's is going to cover the Court of Protection and interesting insights into how care regimes operate in the real world, which after all is what we are all most interested in. I give you one final warning that we may slightly go beyond 6:30, which was the slated time in the publicity, because the two talks together are likely to take about an hour and a quarter, and we'll then have a few questions. It may end up being shorter than that. People should feel free to depart if they need to, but we would very much like them to stay. And those who are here, indeed those at home, will drink with us. Thanks very much.
Well, good evening, everyone. Derek O'Sullivan. AC, I don't quite know what that's for, but I'll just put that over there. I'm going to be doing a talk on the practical implications of capacity in personal injury. It is an overview. It's not supposed to deal with everything, and it's supposed to give you a guide on the areas that we deal with in personal injury practice. We all know that capacity claims have an enormous financial consequence these days. In catastrophic injury claims, the work that I do, claims for a young claimant who lack financial capacity can often add now £1 million or more. In fact, we're probably seeing, I'm sure some of you have seen larger claims than that. And that relates to financial capacity, but of course there's two issues that we deal with, which is litigation capacity and financial capacity. Now, the test for capacity is under the Mental Capacity Act, which I'm sure you're all aware of. We're going to deal with that first, then we're going to look at the application of CPR, Part 21, the role of experts in the court, and then practical issues. And I should have said, because Gus asked, is there a handout? I'm very happy for my slides to be made available for anybody who wants them as an aid memoir, if nothing else. They are, as Arianna said, information rich. In other words, there's far too much text, and so everyone's just going to be looking at the screen, but they are, I hope, useful, and if anyone wants them afterwards, please let us know, and we'll provide them too. The relevant principles are set out in sections 1 to 3 of the Mental Capacity Act. And these are really the keystones. And the keystone of the Act is that a person must be assumed to have capacity, unless it is established that he lacks capacity, and that's section 1 and 2. So there is that fundamental presumption of capacity, and that is the touchstone of the Act. A person is not to be treated as unable to make a decision unless all practical steps to help him to do so have been taken without success. That's section 1.3. That is a very important factor. And we'll get onto that and how it relates in personal injury proceedings, because, as we'll discuss, that is a vexed issue in the sort of work that we do. And I assume everyone here is a personal injury practitioner, or largely so. And those online, hello, I'm sure you are too. We're often in cases, aren't we, in places where the claimant has yet to make a significant decision during the course of litigation. So how that test is to be assessed is a significant issue. And the last point is a person is not to be treated as unable to make a decision merely because he makes an unwise decision. And we'll get on to this still. Not many of us have it, but it's certainly not the key factor in capacity. And as the last arrow at the bottom there, the landmark case of Masterman Lister, the underlying philosophy of the Act is to assist those who suffer from disability to live normal lives and to make normal choices about their lives to the greatest extent possible. Whether we got a late attendee. Now, section 2, this first bullet point, the material time he is unable, the person lacks capacity in relation to a matter if, at the material time, he's unable to make a decision for himself in relation to the matter because of an impairment of or a disturbance in the functioning of the mind or brain. That is section 2.1. That's often referred to as the diagnostic test. That's the first question that a capacity assessor has to ask. Is there an inability to make a decision due to an impairment of or disturbance in the functioning of the mind or brain? So that's the diagnostic test. A lack of capacity cannot be established merely by reference to a person's age or appearance or condition of his or an aspect of his behaviour which might lead others to make unjustified assumptions about his capacity. Quite why the Act decides to refer to someone's appearance in respect to capacity is beyond me, but there we are. It's in there. Section 2.4, it's a matter to be decided on the balance of probabilities. And importantly, it's for the burden of proof lies on the party who is asserting a lack of capacity. So it's not a reverse burden on the party challenging it. The burden lies on the party asserting a lack of capacity. So the diagnostic test is section 2.1. And then the functional test is section 3. And I've sent it out because it's important to be aware of the full provisions of section 3. The main focus in most reports and cases that we decide upon is section 3.1, which is unable to make a decision for himself because he's unable to understand the information, retain the information, use or weigh that part of the information as part of the process of making a decision, and to communicate. It's understanding, retention, using or weighing, communicating. And of course, implicitly, obviously, in the words of section 3.1 is the inability to make a decision. And that's the entire point about the Act. It's about the ability to make decisions. And it's whether someone's unable to or not. 2, 3, and 4 are very important, particularly 2 and 3. A person is not to be regarded as unable to understand the information relevant to a decision if he's able to understand an explanation of it given to him in a way that it is appropriate to his circumstances, using simple language, visual aids, or other means. So we'll get onto this with the code of practice, but there has to be an effort on the part of those who are seeking to assist he in making his or her decision to comply with that element of the Act, because there has to be appropriate measures taken to assist the person to understand what he's being asked or she's being asked to decide upon and make that decision. And 3, the fact that a person is able to retain the information relevant to a decision for a short period only does not prevent him from being regarded as able to make a decision. That's very important. Not only in terms of severe frontal lobe injuries, which lead to a decrement in working memory in post-injury cases, but in respect of other neurological conditions which impair people's memories significantly, such as dementia. So, and that, as we all know, who do personal injury, really relates to working memory. So, but if someone can only retain the information for a short period of time, it doesn't mean that they're unable to make a decision. There have to be steps taken to assist that person. And we'll get onto those. And the last point is the information relevant to a decision includes information about the reasonably foreseeable consequences of deciding one way or another or failing to make a decision. The next slide, if I can get it there. There we are. The assumption of capacity. It isn't just lip service that's paid to this. It is very important. And I've set out there a number of cases, and there's any number of them one could set out which deal with this, where this has been emphasised. the decision of Mr. Justice Carr and King and the Wright Roofing Company is actually an interesting one to read if you get a chance, if you've got a moment. And he said there, partway through his judgment, it's agreed, I cannot twist the meaning of the statutory provisions to protect the claimant from himself and the risk that he will make unwise decisions. The Act prizes personal autonomy highly. And that case was interesting because the claimant was very suspicious of the motives of his solicitors. And there was actually a breakdown between him and his solicitors, which gave rise to a lot of issues in the case. I've given you a reference there to the judgment of Mr. Justice MacDonald in the NHS Foundation and AB case. And finally, Lord Justice McFarlane in PC against the City of York. There is a space between an unwise decision and one which an individual does not have the mental capacity to take. And it's important to respect that space and to ensure that it's preserved, for it's within that space that individual autonomy operates. So those points are all just backing up the presumption of capacity and the importance of it. Wisdom, as we said earlier on, is not required for capacity. It's a truism that most people at some point are unwise or act irrationally. But the Act in section 4 that we went to earlier on, and the guidance, the authorities make it clear that a lack of wisdom is not the touchstone for lack of capacity. The Code of Practice, which is a fairly lengthy document, has not been updated for some time, deals with that and then a number of other points which we'll get to in a moment. But as it says in section 1.4, everyone has their own values, beliefs, preferences and attitudes. A person should not be assumed to lack the capacity to make a decision just because other people think their decision is unwise. This applies even if family members, friends or healthcare or social care staff are unhappy with the decision. Stanley Burton, sorry, there's a typo there, in Lindsay and Wood said something similar. And then a more familiar quote, which is Lord Justice Davis in the DL case, which the tech team seem to have obliterated the bottom of the screen with this. If I press that button, you think we'll lose it? What do you think? Should I try?
I think you can move it out of the way.
Can I? Oh, well done, Sophie. There we go, that's better. Having lost the slides. Thank you, Sophie. Yes, in DL, it's of course of the essence of humanity that adults are entitled to be eccentric, entitled to be unorthodox, entitled to be obstinate, entitled to be irrational. The deciding authority showed there can be no power of public intervention simply because an adult proposes to make a decision or to tolerate a state of affairs, which most would consider neither wise nor sensible. But that just emphasises the point that the Act isn't trying to in some way interfere with people's autonomy or their individuality or their decision-making process based upon their own beliefs. It relates to someone's inability to make a decision because of an impairment of the function of the mind or the brain. Vulnerability and risk of exploitation. It is important. These issues are important, but they're not by themselves determinative in relation to financial capacity, even though there is often a great deal of emphasis put on vulnerability when considering capacity. I'm quoting there from the judgment of Stanley Burton and Jay and Lindsay and Wood again. He set out paragraph 78 of the judgment in Marston and Vista, which I take it everyone here is familiar with that judgment and wasn't dealt with, which included, it's not the task of the courts to prevent those who have the mental capacity to make rational decisions from making decisions which others may regard as rational or irresponsible, repeating the point we discussed in the previous slide. And he said, when considering the question of capacity, psychiatrists and psychologists will normally wish to take into account all aspects of the personality and behaviour of the person in question, including vulnerability to exploitation. However, vulnerability to exploitation does not of itself lead to the conclusion there's a lack of capacity. Many people who have full capacity are vulnerable to exploitation, or more so than most other people. Many people make rash and irresponsible decisions but are full capacity. The issue is, as Lord Justice Chadwick himself indicated in the above passage, whether the person concerned has the mental capacity to make a rational decision. So it is a factor, because of course it's relevant to whether or not someone's able to make a decision, and whether they should make a decision about being exploited or etc. is part of the process. But there is, I think, a risk of too much emphasis being put on vulnerability or exploitation. It is just one factor to be taken into account. Certainly in personal injury litigation, which for those of us who practice and are familiar with the nomenclature, it's all quite straightforward. There are, in fact, a number of issues which can be very complicated to the outside world, who are not familiar with them. But it's not the case that the claimant in question has to be able to understand every element of detail or the minutiae of the law or the facts at issue. Many people with full capacity would struggle to deal with issues in respect of liability or quantum. We can imagine that. I mean, in simple running down cases, for example, that wouldn't be the case in liability. But you can imagine in more complex cases how that would be difficult for a lot of people. Similarly, discussing quantum elements would be difficult. But it's not necessary that the claimant must understand every element of what's being explained here. I'm sorry, I'm using ALJ here. What's important is that he has the capacity to conduct proceedings generally, not specific aspects of them. It's done in the Bergen, which we'll come back to, I will come on to in a moment. Then understand the salient factors, the information relevant to the decision, and the level of understanding required must not be set too high. Now, what are the salient factors is for professional people to decide. And that's one of the reasons why people have advisors. So they can be given advice in simple terms, which are broken down into easily digestible elements. Elements of the code of practice. These are important. There's lots of the code of practice. If anyone ever wants to read it, there's a great deal to it. I thought these were, for the purposes of this talk, probably the most relevant ones. An assessment must be based on the ability to make a specific decision at the time it needs to be made, and not on their ability to make decisions in general. There's a slight tension with that and the notion of someone lacking financial capacity generally. We'll come on to this because certainly in Arianna's world or in the public law world, a great deal of the decisions made in the Court of Protection, as I understand, are very specific decisions relating to very specific issues. But of course, the issue we're generally dealing with either as the claimants or defendants is the issue of financial capacity, which is a blunt instrument. There is an order made by the Court of Protection, general order appointing a deputy, with a determination that the claimant cannot manage his or her property and financial affairs, then that is a decision that's been made in respect to the management of their property and financial affairs. But it's going on to the other elements of it, which are important when considering a capacity assessment. It's the responsibility of those supporting the claimant to ensure that he is put at ease when assisting their decision making. Protracted meetings and also rushing and multiple decisions should be avoided where there's a risk of overload. That's something, for example, which is relevant to joint settlement meetings and mediations, isn't it? With a claimant where there's a capacity issue. Certainly, although they have a litigation friend there has to be consideration of keeping meetings as brief as possible when assessing this. And similarly, the use of visual aids and repetition should be used to ensure that the relevant information has been taken in. So that's all part and parcel of practical steps that can be taken to assist someone with a decision. Visual aids, reducing things to writing, whiteboards, slides, etc. The essence of even relatively complex issues can be distilled to a binary choice by a careful and skilled professional. Obviously, certain things that we deal with, it take quite a lot of skill to reduce it to a binary choice. But that's obviously the aim that the Code of Practice is suggesting, that persons given a binary choice to make. And the information leading up to that decision, put simply, and in a manner which they can digest. Slide. Ooh. Over there. Application of CPR. This slide in particular is more just a little bugbear of mine. We'll get onto it in a moment, but it's because You're all familiar with CPR Part 21, obviously, which deals with this issue. Under CPR 21(1)(2)(d), protected party means a party of the intended party lacks capacity to conduct the proceeding. Then, dealing with financial capacity, under CPR 21(2)(e), a protected beneficiary means a protected party who lacks capacity to manage and control any money recovered by him or on his behalf or for his benefit in the proceeding. Now that's been in place for many years now, without anyone on the Rules Committee noticing. Perhaps someone here could email them about this, because I've never been bothered myself. But the unintended consequences of that is a person who has the capacity to litigate but not to manage his financial affairs is not a protected beneficiary. Because you have to be a protected party to be a protected beneficiary. And I'm not alone, I'm sure, of being involved with cases where someone has had the capacity to litigate, but not had capacity to manage their property and financial affairs. Now, I've raised that only because of it's a point of interest. I've never seen it have any practical consequence. But at some point, the Rules Committee needs to deal with that. I doubt there's anyone who's watching who's on the committee, but there we are. And if anyone wants to email them, please do. These are just some very generalized bullet points here in terms of capacity issues in personal litigation. It's litigation capacity and financial capacity. We could have countless bullet points there, couldn't we, in terms of what sort of decisions a person injury claimant has to make. Looking at litigation capacity, for example, whether to commence settlement negotiations or gather more evidence first, whether and if so, at what level to make an offer, whether to contend for lump sum compensation or periodical payments, whether to accept an offer. That list could go on and on. But, so you could see these are all discrete decisions that need to be made, and some of them will be more complicated than others. Explaining the difference between lump sum and periodical payments, for example. But if you took an ordinary capacitous person and sought to explain to them how the discount rate works and what the basis of it is, and I'm sure most of them would not be able to understand that. That's no criticism, a lot of people can't. So you don't have to get to that level of detail, but in things like, well, should we take a lump sum? Should we, for example, seek periodical payments? That's a careful decision, which would be quite complex for most people to deal with. But it would be something that would need to be made in a personal litigation. So capacity could well be an issue on that. And then in respect to financial capacity, again, the list could be endless. But when considering whether or not someone has the capacity to manage their property and financial affairs, these are the sort of questions which generally come up when I'm considering, particularly with experts, whether and if so for whom to seek advice as to how best to invest money. So would the person know and understand that they should be seeking advice, for example? Whether the advice given can be understood. If someone goes to see a financial advisor or wealth manager, would they know to do that? Would they be able to understand the advice that's given? The type of investment strategy to be followed, bearing in mind the needs which the damages were awarded or were agreed. So again, would someone realise, well, I've got care to deal with, I've got other heads of claim that I need to deal with. How should my money be invested to ensure, for example, that I can be looked after, that I can be cared for? Whether the person in question would like to set up a PI trust so as to protect any ongoing entitlement to state benefits. Obviously, if someone lacks capacity, that's a different matter, but even just the asking of that question is obviously is an issue in terms of whether the person has financial capacity. As I say, that list could go on and on. And I've got to be a slight care that I don't go on and on. I think I don't have my watch, but Arianna will tell me when
Just at 6 a.m.
6 o'clock. I'm going to move on. The role of experts. Who decides capacity? Allen Caton, it's familiar words, and it's been repeated in a number of cases. Across the board in every type of litigation. On all issues, and capacity is no different. The question of the mental capacity is in the end the matter of the court. The expert evidence, in particular that of the neuropsychologist in this case, was capable of providing a psychologist's view of the question. It was an important facet in the equation, but the judge had to weigh that together with the evidence from other quarters as to how the claimant presented and how he practiced, and in practice how he functioned in day-to-day life. The opinion formed in the consulting room does not dictate what happens on the street or in the home. That's very important. And that's obviously why it's important for there to be factual evidence of how the claimant in question is, use those words, performing and functioning in day-to-day life. And the court will take into account the views of family and friends, very much so, as well as the experts, who I've said there tend to come from neurology, neuropsychology, and neuropsychiatry, with neurology being relevant to the diagnostic test, but the other two disciplines being much more relevant to the functional tests, particularly neuropsychology. But in Lindsay and Wood, Stanley Burton J. Relied very heavily on the factual evidence of the family and friends, because obviously neuropsychometric testing by a neuropsychologist is carried out in a consulting room, in a calm environment, in a structured way, and even though it's over a number of hours, it can't tell the whole picture about claimant's function. We see this relatively frequently, don't we? Claimants' neuropsychometric test results might only reveal relatively subtle deficits. And executive function tests by neuropsychologists might not reveal much at all, but the family might be reporting very significant disexecutive issues. And that's why the role of family, friends, support worker records, etc., are very important in the assessment of capacity. Practical issues, ensuring capacity is properly dealt with. Section 1.4 and the Code of Practice and the authorities are all clear that overturning the presumption of capacity is an important decision which requires proper consideration of the statute. I don't think this is limited to my own experience, but many experts instructed to deal with this frequently do not apply, in my view, the Act or its COP properly. Even now, 15, 18 years after the Act came into force, you still see the case that many reports contain no detail or analysis, no capacity assessment, and just simply say the claimant lacks capacity or the Court of Protection should be appointed. And it's also often the case that the wrong test is applied, which is that the claimant, this is one sees frequently, the claimant cannot make a decision in his own best interest. That's not the test. The test is whether they are able to make a decision. And so there must always be, obviously the diagnostic test under Section 2 is implicit, but there always has to be an emphasis on the functional test in Section 3. Now, there's also very frequently a lack of focus on the issue of the steps that could be taken to assist the claimant to make a decision. And I've said that, and all this process has not been tested. I mean, that is a point which is conceptually quite difficult, but does need to be dealt with. In other words, if the litigation has not reached the stage where a claimant has had to make a decision of any importance, so it hasn't been tested whether all practical steps could be taken to enable him or her to make a decision, that needs to be identified. Because it's, as I say, one of the touchstones of the Act is Section 1.3. So parties must be very astute to ensure that capacity is considered correctly. And although things are getting better, to say it's my view that in a lot of cases it's not. As I was saying to Arianna before we started, there's almost a, if I want to say this because I don't really know enough about the public law side of things in the Court of Protection, but in the personal injury world, capacity is dealt with, so it seems to me, from my limited understanding of public law world, and other arenas in which capacity is important, health decisions, that sort of thing. Capacity assessments in personal injury tend to lack the rigour that you get in other domains. So a pro forma set of instructions for experts in relation to capacity is a sensible step. which will include setting out of the Act, reference to the guidance of the Court of Protect of the Code of Practice, and ensuring an expert deals with those steps. Setting those out is not an improper set of instruction, not leading an expert to a conclusion. Part 35 questions. I don't want to sound like a teacher and I'm running the suck eggs here, but part 35 questions are obviously a very useful interlocutory step that capacity has not been properly considered by reference to the MCA and its COP. Too often it's just left to a joint statement stage, and then the experts provide a joint statement, which the parties then have to try and juggle without then having the ability to ask questions unless they make an application to the court. Just have to remember you have a right to ask questions for clarification if they're served within 28 days of service of the report. I put the reference there to expert shopping or selective disclosure is absolutely impermissible. Everyone should be aware of the decision Mr. Justice Kenneth Parker and Lachlan and Singh. I won't go into that now. If you haven't read it, have a look at it, but it did involve an expert providing one view to the Court of Protection and another view to the court and changing his mind. Something I think he's probably lived to regret. Practical issues. What is the basis for the lack of capacity? I put this in, and it was important with what I said earlier on, that it's, I think, incredibly important that we all put ourselves in the position of whether or not it's going to be said we lacked capacity to manage our property and financial affairs. And again, this might just be me, but experts must bear in mind that if they write off the person's financial capacity, that is a blunt instrument with a profound effect. If an order is made by the Court of Protection appointing a deputy to manage someone's property and financial affairs, unless that order is discharged, that order remains in place. It effectively infantilizes an adult. They lose their economic autonomy and freedom. So real care has to be taken with respect to opinions in this area. I've set out a very brief few lines there in respect of neuropsychological testing. There's an awful lot more that can be said about that, but particularly with regard to neuropsychometric test results, decision making is heavily dependent on working memory. We know that's one of the WACE-4 domains. Working memory skills and neuropsychological profile should be carefully considered to see if he has the intellectual capacity to understand relevant information pertaining to the purposes of making decisions. So a claimant with a frontal injury may well have significant weakness in working memory relative to his other abilities, but he may still function in other domains sufficient to manipulate information and allow decisions to be made, so long as all practicable steps are taken to assist him or her in that process. The upshot of that is neuropsychometric test results by themselves do not determine whether or not someone has a lack of capacity. So someone might have a significant decline in cognitive functioning. Their full-scale IQ might decline from 100 to 75, for example, on the test results. And they might have a very significant decrement in working memory. But their processing speed and their perceptual reasoning and their verbal and visual comprehension might remain at a higher level. And so it's a nuanced decision to be made in respect to the test profiles. It's not a blunt instrument, which leads to a decision automatically one way or the other. And as I've said there, surrounding evidence, such as support worker notes, medical records, etc., will often give an indication of function. They have to be taken into account. Next slide on practical issues. When should capacity be determined? As you're all aware, it's entirely open for a defendant to plead in a defence dispute as to an alleged lack of litigation or financial capacity, or to identify the issue. And that then puts capacity at issue. The appointment, the threshold for the appointment or the need for litigation friend is actually very low. And sufficiently low that the fact that the claimant proceeding via a litigation friend is not in any way determinative that the claimant lacks litigation capacity or financial capacity. It merely means the solicitors acting for the claimant have some grounds for believing the claimant lacks litigation capacity. It's well worth being aware of what was said in paragraph 80 of Master Vista. Normally, no problem arises as to when the issue of capacity should be raised. It raises itself. A responsible solicitor acting for a claimant or defendant has doubts about the capacity of his client and seeks a medical opinion. If the opinion suggests that the client lacks the necessary capacity, then the solicitor arranges the appointment of a litigation. So if there are reasonable grounds to suspect that there is a capacity issue, then expert evidence should be obtained. And if the expert evidence then suggests there's a lack of capacity, then there should be an appointment of a litigation friend. As was said in Folks and Vasey, provided there's some supportive evidence, the claimant solicitors can apply for a litigation friend to be appointed even without a determination of capacity. The application can be made without notice. So there doesn't have to be, for example, a formal capacity assessment before the court of protection. Like that. The level threshold is low. It was suggested in Masterman Lister that capacity should be tried as a preliminary issue. And there have been instances of that. But certainly, more recently, and in the last decade, so in my view, it's more common for it to be tried as part and parcel of the litigation itself. The majority of the recent cases involve capacity being determined along with all the other issues of quantum. But there is nothing stopping it technically being determined as a preliminary issue. How that will be cost effective certainly in the modern world and the modern budgeted world is another matter, but it certainly would add to costs if that was done. And the final footnote there, final bullet point, is that the defendant, or you will know, there's no locus in any application by the claimant to the Court of Protection during the course of personal injury litigation. So the claimant makes an application for a general order, for example, the defendant has no locus, no standing, no ability to intervene with that or make submissions to the court. Settlement of capacity is an issue. This is interesting. Well, it is to me anyway. Well, you are permitted to smile. The cases frequently settle where capacity is firmly an issue. We've all had these cases, where there is a dispute on capacity. It wouldn't be obviously in a barn door case where capacity, there can be no doubt because of a very severe traumatic brain injury. But I'm sure everyone's been involved and online as well in cases where there is a genuine dispute between the experts, particularly in a borderline capacity case, where on one side the claimant's experts, for example, are saying, well, the claimant probably just about lacks capacity, financial capacity, and the defendant's experts say, well, no, we don't believe that's the case. But that's not a bar to settle in any shape or form. And these cases where there isn't a capacity dispute, in the marginal capacity cases, shall we say, where there can be a range of opinion, they do frequently compromise. And the court is then asked to approve it, with the cost of the approval hearing being part of the cost of the litigation. It's a time error, where am I going on? Okay, forgive me. I like the sound of my own voice too much. Right, quickly then. There's nothing illogical or incoherent in such a step being taken with the parties coming to a compromise and asking the court to approve it, even where capacity is in dispute. Because, of course, of Dunhill and Bergen, a case where a case was set profoundly undersettled many years ago, was then reopened because it was determined the claimant lacked capacity. And as you all know, I'm sure, until the court approves a settlement in a case of a incapacitous claimant, there is no binding compromise. So it's often the case that both claimant solicitors and defendant solicitors will want an approval in a case where there is a marginal capacity issue or there is a capacity dispute. Coles and Perfect, the judgment of Mr. Justice Tier, an unusual case, actually was in claim under the Shipping Act, which some commentators have said it doesn't apply generally. But Mr. Justice Tier decided that in a case which was a marginal capacity case, albeit the claimant was on the right side, the court had an inherent power to approve a settlement. So that is something which, in a number of cases I've been involved with, that's been important. The parties have asked the judge to approve a case even where the claimant had technically, informally had capacity. Other issues, claims for welfare deputyship, we're not going there for another talk all on its own. Cost of administering personal injury trust is not generally recovered by a claimant with capacity, and the authorities are cited there. Interesting decision in Martin and Salford Royal NHS Trust. The claimant, being a vulnerable individual, did not lead the judge in that case, Mr. Justice. Sorry, it's not Judge Burson, he's a High Court judge, to exercise a protective jurisdiction to award damages for a personal injury trust. Again, that's a point that's worth being aware of. The extreme situation, another issue, EXP and FZZ and DXW against PXL. They were cases where the court made an order that the claimant who lacked capacity should not be informed of the terms of the settlement. Again, for claimant solicitors, if you were ever in that situation and you have anxieties that the claimant should not be told of the terms of the settlement because you'd be concerned about him telling people about it, and that was the case in DXW's case I was involved with. There was a power for the court to make that order. Although the judge in DXW did actually say what the settlement figure was in the course of the judgment. I did afterwards, but ignored. AV in Royal Devon, that's a case where a claimant's lack of capacity was due to heroin use, not due to the spinal injury. So on the grounds of public policy, he was denied any damages in relation to the capacity claim. What if the claimant doesn't provide a witness statement? Again, this is an aide memoir for those of you who might be facing this point. There are conflicting decisions, Brown and Jabal and G against Assad, as to whether a court can order a claimant to attend court to be cross-examined, or whether the court, for example, could draw a negative inference against a claimant who doesn't provide a witness statement, but who has, of course, spoken to all the witnesses in the case. So the court is hearing hearsay evidence from case managers, etc., and experts who've spoken to the claimant and are relaying what the claimant has said, but not hearing from the claimant. The new provisions in respect to CPR 112A about vulnerable witnesses no doubt will probably change the law on that, will certainly be important. But that slide in itself, frankly, could be an entire talk. But I have speeded up, so that's my talk done. I'll happily answer questions at the end once Arianna is. Oh, there was a clock there. Sorry. What about this now?
Good evening. My name is Arianna Kelly. I practice mostly in the court of protection and in public law cases with a focus on community care. And hopefully I'll be able to navigate these slides without too much difficulty. There we go. What I'm going to be talking today will be a couple of points which I think may be of interest to folks around transitions to adulthood specifically. I would caveat what I'm talking about in saying that a lot of the cases that come before the court of protection, almost by definition, something has gone wrong or people have fallen out in some way. So obviously there's many other cases in which things are going well. Settlements are providing really good quality of life for people. Those don't tend to spill out into conflicts in the court of protection. So I'm not really looking at those. What I will be looking at is a couple of things. One is around the changing role of parents in the lives of people who have serious disabilities. I'll also be looking at deprivations of liberties, access to statutory service, and promoting independence. The first thing I wanted to talk about was an example of one of these cases where things have gone quite badly wrong. I've changed around the facts a little bit just to anonymize the person, but this is broadly the outline of what had happened in this case. G was a man in his late 20s. He had suffered a brain injury as a result of a road traffic accident. He had a settlement of £1 million lump sum and £83,000 a year for a periodical payment. He had an expensive national, well-regarded corporate deputy that you will all be aware of, but obviously I'm not going to name in this case. But suffice to say, highly reputable deputy was involved in this matter. The deputy had arranged a care package which was very much in line with what the claimant's expert had thought was appropriate within the course of the PI proceeding, which was 22 hours a day of care. However, the road traffic accident had been 14 years prior. G had engaged with a lot of the therapy and rehabilitation work which had been set out. When the deputy approached the local authority for statutory funding on the basis that their money was running out, the local authorities asked this man several times over the course of 4 years because the request was made repeatedly over this period of time. I think he was looked at by at least 3 social workers, and potentially more, as well as their managers, and these were again experienced social workers. They felt that this was essentially a safeguarding issue, what was going on in the case. They felt that this man needed no more than 5 hours a day of care and support, that he was being badly stifled, and the care regime was oppressive to him. They had tried to raise it with the deputy and care manager on a number of occasions to say, really, this man does not need anywhere near the level of care that you believe he needs, but they were met with relatively limited responses to that. They also noted that his money was being burned through very quickly. His lump sum was almost entirely gone. I believe he had about £12,000 in the last approach to the local authority, having started with $1 million. He did own his own house, I should say. And they were overspending on the periodical payment year on year. His capacity to make decisions to his residents in care had never been considered by his case manager or the deputy. The local authority felt he had capacity in both of these domains. When they talked to G about this, and they gave him statutory advocacy services, well, G was very clear that he much preferred what the local authority was proposing for his care and support. He did not understand why he had 22 hours a day of care. He didn't feel that he needed it. He had local family. He had a good network of friends. He was particularly involved in the disabled supporters group of his local football team and had a lot of really positive social connections through that. He wanted to have a girlfriend, which he felt was very difficult to do with 2-to-1 carers following him around all the time. And essentially, he was living in what was an unauthorized deprivation of liberty with no assessment of his capacity for an extremely long period of time. This was again very much justified when the local authority raised it, saying this is what the claimant's expert said he needs. My overall point on this is obviously a case where things have gone very badly wrong in the aftermath of it. The PI proceedings had ended a very long time ago. This was all very much in the past in terms of that. But there really had been a failure to reflect on where he was now and the progress he had made, the successful rehabilitation which he had undertaken, and his own abilities as they stood in the here and now. The care plan, I would say, had locked on the basis of the claimed evidence. His money had been spent. He didn't actually have anywhere near as much as he could have had if the care package been canceled years ago. And it was really only the money running down to almost nothing that caused the deputy and the care manager to reassess what had happened in this case. I'm not trying to suggest by any stretch of the imagination that this is a representative case, but I think the point is more, it's very important to recognize how people grow and change, and assumptions which might have been justified or grounded in evidence 14 years ago were not actually borne out by the reality of this person's situation, and unfortunately, his personal injury award had become a cage for him rather than something that was enabling him. So, in looking at what the COP approach is, it's always really important to look at the specifics of the case. And I think one of the points that Derek was raising as well is that capacity is always considered in the here and now. Can you make this decision at the time when it actually needs to be made? What are the relevant facts at the time the decision needs to be made? And that's something that's going to be continuously changing throughout the person's life. One of the things that you see really commonly is that there's a huge change in maturity of people as they go from children to teenagers to adults, as there would with anybody. There are obviously some cases in which an injury is so catastrophic that a person's decision-making ability may not come on as in a way that meaningfully changes their independence or their ability to make decisions. But it's also not uncommon that it does. People grow and change in their life experiences, even if people perhaps have difficulty learning new information because of brain injury they might have. With repetition, with time, with that maturity, they may come to that point. And it is something that you regularly see in the court of protection of deputies seeking to be discharged because the person has regained financial capacity at some later point in time of their life, because with time and with experience, they have come to be able to make those decisions despite the brain injury that they may have. So one of the things that I think is also an interesting point to look at, and I think may have some relevance for your cases, is the changing role of parents and families in a person's life. Because again, in many of your cases where people settle these cases as children, their parents will be taking a very prominent role in their lives. And that role may develop and change over time, both because of the preferences of the person and the preferences of their family. This also changes how decisions are made around the person. Something that parents often find really difficult is the idea that parental responsibility comes to an end and they are no longer the voice in the person's life, because often this is someone who will have been fighting the child's corner throughout their lives. They see themselves as their advocate, they see themselves as their voice, and learning that the person on turning 18, they don't actually have that priority can be something that can often be very distressing for parents, and often it comes into a reconfiguration of how decisions around the person are made. What I would say is, while there's no particular hierarchy within the Mental Capacity Act, I think the first voice that you try to listen to is the person's rather than anyone else. And you may not always be able to hear from the person, you may not be able to follow what the person has to say, but you would always need to listen to the person. And Section 4 of the Mental Capacity Act specifically pulled out the voice of the person as something that would need to be taken into consideration in any best interest decision about the individual. 16 and 17-year-olds, as they're making that transition, are covered by the Mental Capacity Act, and the presumption of capacity applies unless it's displaced by evidence of incapacity, as Derek was discussing. One of the things that also may happen, particularly after a personal injury award, the parent may step back from their role as a carer. They may start to defer to a paid care team to a greater extent. There may be sort of a rebalancing of who is directly involved in caring for the person. One thing that you also see sometimes on turning 18, this is not uncommon, I've been told this by many parents and families, is that on the person turning 18, they are informed by someone with local authority, I am now the decision maker for this person's life. Similarly, I've seen care managers hold themselves out as saying, I am the decision maker. I've seen deputies hold themselves out as I am the decision maker. It's really important to understand the deputy is really only the decision maker around finances. There was a case from about 3 years ago called RE-ACC by Senior Judge Holder, the Senior Judge for Court Protection, which is very clear the deputyship authority is property and affairs authority. It is not broader than that. And even if they're taking decisions around care, they are not the default decision maker around what is in the person's best interest in relation to care. And certainly no deputy or no single person can ever authorize a deprivation of liberty of the person, which certainly when you're talking about 24-hour care packages, it's very likely that this will result in a deprivation of the person's liberty. One point, and we were discussing this prior to this event this evening, is since the Lawson, Hopton and Mottram case a few years ago, there has really been a spike in applications for welfare deputyships in the Court of Protection. While the decision in Lawson, Hopton and Mottram took away some of the bite of the statutory guidance, Code of the Mental Capacity Act Code of Practice, which, if I can summarize it, said that health and welfare deputyships will be as rare as hen's teeth. They will still be decided on a case-by-case basis, but in reality, they are still rare as hen's teeth. They're very uncommon to be made. I think I've seen some statistics, so I'm not going to attribute these. It's because I'm not 100% sure as to whether this is right. I think it's somewhere around 250 to 300 a year are actually granted. Many more are made. But the Court of Protection will always want to understand why a single person should be put in charge of a person's welfare, which I think is ultimately a really important question, because this is something that develops over the course of a person's life, and different voices may take greater or lesser prominence, where the normal assumption of deputyships is that they last for an indefinite duration. The cases where you see them granted are often still in line with what's in the Code of Practice, in terms of if you have a person who has a lot of linked decisions that need to get made. So often sometimes people who have a lot of really serious health decisions, which will have to get made one after another, after another, after another. Sometimes it is really helpful to have the sole decision maker so that you're not having to convene best interest meetings constantly for this person, make the decisions over and over again. But what I've also seen is many people who at the age of 17, 18 years old are very happy with the idea of their parents being decision makers, don't necessarily want that later in life. And certainly for paid professionals, I would say it's very questionable as to whether or not they should be put in sole charge of anyone's welfare. The purpose of the Mental Capacity Act, and Section 4 of the Mental Capacity Act specifically, is the idea that people make collaborative decisions, that you hear all the voices, and if there's a dispute, that's what you go to the Court of Protection for. It is often much more successful than people think in terms of convening best interest meetings, talking things through. And I've seen many, many cases where people didn't think there would necessarily be a resolution to be found, where it ultimately, at the end, people are able to come to an agreed resolution of what is in the person's best interest. So from my perspective, I would say health and welfare deputyships, there are some cases where they may be appropriate. There are very limited cases, generally on very specific facts, and the Court of Protection for granting any health and welfare deputyship is going to want to really see some clear evidence as to why you can't just make the decisions informally or go to the cop if that's something that needs to be done. In terms of the role of parents and families, again, one of the things that you often see changing after personal injury award is this idea of parents stepping back, but some people do remain involved closely with their child's care as the child goes into adulthood. particularly in cases where the person perhaps doesn't have an overwhelming settlement. Parents may take a very prominent role and use the awards in more dynamic ways to fill in gaps of care or to get better, a more suitable accommodation, provide therapies, and that sort of thing. One case which I would highlight, just because I think it's of interest, is a case from 8 years ago, the David Rawson A case. This case was decided by Senior Judge Lush, who is very well regarded senior judge in court of protection, really knows what he's talking about in terms of these things. This was an application by a deputy for retrospective authorization of a decision to pay the school fees of the brother of the person who received the personal injury award. A had just turned 18. She had a £5 million lump sum settlement with no periodical payments. She had a brother who's referred to in the judgment as B, and the judgment summarized that during his infancy, much of the parents' time and attention was focused on A's complex needs. As a result, B's physical and emotional needs tended to take a back seat. In the lead up to the trial, which coincided with when B was looking at exams for his grammar school, his grades really suffered. He was not admitted to the well-regarded local grammar school and was offered a place at a school that was a considerable distance away from the family home. I believe the parents would have had to spend something like 3 to 4 hours a day transporting him back and forth to this school, which would then be time that they would have to take away from A. So they would either have to find substitute care for A during that period of time, or what they asked the deputy to do, and the deputy took what the court considered a really careful decision, was that ultimately it was in A's best interest to liberate the parents from this responsibility by sending B to a well-regarded private school, which was very nearby. This actually ended up in contested proceedings in the court of protection because the official solicitor opposed the application by the deputy. But Senior Judge Lush wrote a really careful and thoughtful decision talking about the way that the personal injury award was being used in the view of the court was actually promoting A's best interest. And this was a decision which the court endorsed. One of the points that they made was this idea of mutual dependence. And just to quote this briefly, many, indeed most families are as dependent upon a damages award for personal injury or clinical negligence as the recipient of the award is dependent upon their family. Parents in this situation are all too aware of their reliance on their child's award, and it is both insensitive and demeaning to stigmatize them for deciding to sacrifice their own careers and earning potential by staying at home and caring for their profoundly disabled child on a full-time basis. A's well-being is dependent upon their well-being, and this involves being together, meeting each other's needs, helping each other pursue their dreams, and enjoying a satisfactory quality of life as they can in what are by any standards extremely exacting circumstances. Their well-being also involves foreseeing and avoiding setbacks and negative experiences wherever possible, and is clearly advantageous to A to reduce the levels of burden and anxiety within the family in a manner that is likely to have a positive outcome for anyone. So I just highlight this again because I think this is an interesting case in terms of how the COP will come to look at these questions, because this obviously played out in a way that no one really could have anticipated in the course of the case. No one could have necessarily predicted B wouldn't get into the grammar school. No one could have predicted that the parents would have potentially been taken away from caring for A, because this was obviously very much their intention and what they had hoped to do, and what seemed to be working out very well for anyone. But I think it is just one of those points again of matters change, and the COP will take a flexible approach based on circumstances of the case, and will really broadly in terms of its consideration of what is in a person's best interest, particularly where they are existing within that family, and A's ability to remain in that family, which was described as a very loving and supportive one for her, was going to be aided by spending her personal injury award in an unusual way. I'm very cognizant of the time, so I'm just going to touch on some of these slides. I'm very happy to pick any of these up in questions or in a discussion after this. One thing I would note again around parental responsibility for deprivations of liberty, I think a lot of care needs to be taken around this as well, because often people don't recognize that deprivations of liberty can happen in the home, that they can happen on a private basis, and they can happen as a result of a person's family caring for them. If a person, the normal assumption for 16 and 17-year-olds would be that they are not going to be subject to continuous supervision and control by their parents. Their parents can't consent to this, and it is something that would potentially have to be looked at, either a joint care package or even the family looking at it primarily. I'm going to park this slide. Largely, this just talks about when children are considered deprived of their liberty. There's a recent case which said that if there is no dispute, a parent can consent to the deprivation of liberty of a non-guilt competent child under the age of 16. I think that's a relatively controversial decision and probably will be revisited by the COP at some point in time. In terms of what you would potentially need to do and costs that would be associated with this, There are a number of courts that you can go to authorize the deprivation of liberty for children. It depends on whether the child is over or under the age of 16. It depends on what the child's circumstances are. Usually, if you're talking about someone lacking capacity and over the age of 16, you would go to the COP. Under the age of 16, you usually go to the inherent jurisdiction of the family division, but that can be heard. They can hear 16 to 18-year-olds as well. It's usually not appropriate to use what's called the streamline procedure. If you're making an application to the COP, which is the less expensive version of authorizing the deprivation of liberty, you would normally bring that as what's called a welfare application. Again, I'm happy to pick that up if anyone's interested, but I think I'm probably more interesting to talk about some of the statutory services points, so we'll come over to those. In terms of statutory services from children aging out of children's services and going into adulthood, one of the things I think is really interesting around both Care Act services and CHC is that the duties around adults are much harder edged than the duties around children. Most children duties are target duties. It can often be very difficult to get a full statutory package of care for a child in that situation. I put a number of points around the Care Act, but there are really clear duties around assessment and the rights of the person to be involved, the obligation of the decision maker to consult with carers and other people who are involved in their welfare, and to understand what goals the person is wishing to achieve. There are also really clear duties to continue any services that the person was receiving as a child if the assessment has not happened before the age of 18. In terms of funding, this could probably be a talk on itself, but again, in general, capital held by PI awards is disregarded if it's held by a deputy or in a PI trust. The treatment of income is much more complex, and specifically the treatment of periodical payments is much more complex than that of income. And this is something that particularly local authorities in stretched circumstances, I think, are pushing back on more and more when they are approached for statutory funding by someone who has a regular periodical payment, and they may likely want to see more information about that before making any decision as to whether or not the person meets the means test. The positive aspects around health, again, continuing healthcare is much harder edged than children and young people's continuing care, though there is a lot of variation across the country in terms of access to NHS continuing healthcare. But it is something that is not subject to any means test. I think, again, we were discussing, we probably do another whole seminar just on combining personal injury awards and NHS continuing healthcare. The general rule is that you cannot combine personal anything with an NHS funded package of care. However, CHC has an obligation to put in place a complete package of care for the person's needs. Once they've taken that assessment and decided what package of care they actually are putting in place for the person, there is sometimes scope to put in other care that the NHS has decided that the person does not require to meet their needs. And so you can have the two of them running alongside each other. Though it is usually best to try to draw as clear a line as possible to avoid conflict with the NHS around that. One other issue that you do sometimes see around health and transition is commissioning gaps. Often services do change for people when they go from being children to being adulthood. I've often seen this around diabetes services and other things like that, where there are simply things available for children that aren't available for adults or vice versa. And I think that may be something to factor in terms of what services the person might be entitled to as a child, and perhaps what services they would need to purchase as an adult, because they may simply not exist. So that's obviously always going to be a bit of a shifting sand in terms of what the ICBs do or don't commission. The final piece, just mentioning, and I think this is one that specifically ties in with some of the welfare deputyship points, is just another example of the case of Jay, who was someone who had a very close relationship with her parents as a child. She had done really, really well. She had a very, very supportive family. They had really done everything for her and pushed her and supported her and been very, very involved with her. She had gained quite a lot of independence. She had moved into a supportive living accommodation, and she had a fiance at the time that we became involved. They lived in the same supportive living accommodation, and they wanted to get married. The parents and the deputy both opposed this. They felt that she was not ready. They had a lot of concerns about this, and they considered that she lacked capacity to make decisions regarding sex and that she needed to be protected. Jay was assessed by the local authority. She was assessed by her by various NHS bodies. She was assessed by an independent expert. All of them were really clear that she had sex capacity. She also had capacity to make decisions around contact with her boyfriend. And the view of the local authority was that they were living together because her boyfriend was someone who also had needs in his own right, but they were very supportive of each other and did well, and they were living near to other support, that they would no longer need 24-hour-a-day care. I think this is, again, was one of those examples I would put out in terms of people who, at the age of 18, Jay absolutely would have supported her parents having a welfare deputyship. By the time she was 25, they were not seeing eye to eye about almost anything, and actually she felt that her parents were very stifling to her. So I think it's just looking at the COP perspective on things. I think there is usually a push within the COP to do positive risk taking, to think about the person's independence and really to think about what they want. I think sometimes there is a legacy that happens of people seeing the person as a perpetual child. It obviously doesn't happen in all cases, but it does happen in some cases. And sometimes that can lead to the person being prevented by people who care about them deeply and wish the best for their welfare, but perhaps don't always see how they have changed and moved on. And I've just noted in terms of the statutory services, one of the difficult thing about statutory services is they're extremely strained in terms of resources, but one of the positive things about statutory services is that they usually do have this very strong drive towards independence, and that is the ethos of them. And I think sometimes you do see that push-pull that occurs, particularly if the person ages and matures. That was my whistle stop tour, but obviously happy to discuss.
Right, are there any questions? Don't be shy.
Well, we have quite a lot of people attending online.
Oh, do we?
So I have been given a question that has been shared on the chat up there, which is, I think, obviously coming from a claimant lawyer who is representing someone.
A specific question asking for free advice.
On the way towards the trial. I think they're waiting for the trial to be stepped down. An offer has been made on the case. The client is funded under a CFA. The client has declined advice, both of solicitors and counsel, to accept an offer of settlement. And the instructions are clear that they want millions. The solicitor is concerned about capacity, but the expert evidence doesn't support the finding that the client's incapacitated. So they are seeking a further referral for a medical report to potentially consider referring into the COP. So the solicitor has instructed another expert with the permission of the court. The concern is what happens if the client now refuses either to cooperate or to attend that appointment with the expert, so that the expert can't give any opinion, and where they are is left with the medical reports that are before the court.
Charlie, you were shaking your head there. Do you want to answer that?
I was shaking my head because I'm not sure it's appropriate to give any answer.
Well, I'm not going to. I'm sorry. That's not a question arising from my talk, and I frankly don't feel it's appropriate for me to give advice in a public forum on a matter which is obviously very important and needs the advice from counsel in the case.
Exactly.
Would you agree with that, Charlie?
Absolutely. I'm exactly the same instincts.
I'm being difficult. It's a very tricky point, but I'm not being difficult. But it is the case that sometimes in these Q&A sessions, people say, oh, "I've got this case," which, you know, sometimes it's fair enough. It's a point of generality, but that level of detail and that level of complexity, it's not something I think I'd feel remotely appropriate for me to give any views on.
Derek, can I ask a question? Just
Not about one of your cases. I've got this case.
It's someone else.
Yeah.
It's really a question for both of you about the situation that Arianna was referring to, where there was a change, that case where there was a change in the development of the child, the needs, when they became an adult, the needs became far less, but no one spotted it. It's the sort of thing that is a nightmare situation, but what occurred to me was, does that sort of thing happen all the time? And we just don't know about it because no one, if you're talking about a private law claim, the defendant has lost any locus in the situation, and the claimant's lawyers probably aren't involved either.
I know. I mean, I've been involved in a number of similar cases like that with local authorities, because it often comes up in cases where I think sometimes that these things get spotted is when the local authority has been approached. And you know, the reality of it is that local statutory services have a vastly different view on what an appropriate care package is. So, I mean, I think you have to take that with a certain grain of salt in terms of saying they're looking at it from their lens of what would we normally do for a person like this. That being said, I have had many, I mean, I should say, I spend a lot of time in the COP. I mean, I've had many in the COP where you do get these deputies that are just massively over providing care. That, you know, it really does become this locked in scenario, and they're not adjusting, and nor are they really listening to the person. And I think that's sort of why I highlighted, because it is a real thing. It does happen. I wouldn't offer any speculation as to how frequently, I suppose.
Before the question is asked, can I just say on that? I thought for a long time there's the person injury world and the COP world are just siloed, and there's too much of a gap between them. So the knowledge and information and experience that the Court of Protection has and its practitioners isn't shared with the person injury world, that's why I think there could be an awful lot learned from the Court of Protection, its experience, etc. Now, of course, there are the judgments that we can all read, but you know, the points that Aaron has been discussing. I'm sorry, Camilla, there's someone else who was in before you.
It's just on that point. I think I went to the Babacom conference last week, or 2 weeks ago, and the situation is there. The case managers don't understand what social workers do.
No.
And vice versa.
Yeah.
Social workers have no concept of what case managers do.
No.
I think there's also very close relationships between case managers and specific deputies, the way they work, etc. And I was going to ask Arianna as to whether or not it would be a good idea to sort of have a periodic review, you know, somebody objectively outside coming in to assess what care that person, say every 5 years or every 3 years.
I mean, theoretically, that should be a DOLS review. I mean, you should be reviewing that once a year, but I mean, but in that case, they hadn't actually acknowledged that was a deprivation of his liberty, and they hadn't made, because I think it would have been picked up much sooner if you had to submit that on an annual basis, because I mean, that is the purpose, is to make sure that you're not putting something that's unduly restrictive in place. But I think in my personal experience, very often, I think a lot of people fail to recognize that it can be just as oppressive to be in your own admittedly lovely home with a bespoke package of care with two people that never leave you alone, despite you're asking them to do so. But I mean, I think when people say, well, that's not adult because he's not in a care home, or that's not adult because he's not in a placement, but it's very much.
I mean, the thing is, you know, if the acid test is you're not free to leave, Chester, then I mean, DOLS, that whole, because the LIPS procedure is not in place, and you have any idea when it might be? No. The whole issue of deprivation of liberty could be a talk on its own, couldn't it? Because we're all personal injury lawyers in this room, aren't we? And so one issue that I deal with all the time, and I'm going to ask Arianna a question now, so she can deal with one of my cases.
That's fine.
That's fine. What do you have where you have a situation with a young person, for example, with, you know, severe TBI with behavioural issues, who, for community safety and their own safety reasons, it's being suggested that they have 24/7 double up support. I mean, there is a deprivation of liberty there. And you have the issue then, which the deputy will have to struggle with, and the case manager will have to struggle with. Well, two support workers cannot physically restrict, you know, a male or female claimant from legal. You have some very tricky legal and conceptual issues with that.
Well, and I think this is sort of this be the whole point of going into court protection and getting those authorizations, because I mean, we have to do these cases in the court protection on a very regular basis, where you authorize restraint, you authorize, you know, positive behavioral support.
That's under Section 4A.
Well, yes, but and I mean, so and sometimes you have placements where situations where a person is in a placement and their general deprivation of liberty is authorized by standard authorization, but there's a view that the standard authorization actually shouldn't go so far as to cover things like, say, rapid tranquilization, you know, actually. You know, it's very invasive, you know, what happens to some people in these cases. And sometimes there is a view that even with standard authorization in place, you should go to the COP. Very often, and I have to see, I feel like we've been seeing increasing numbers of these in the last couple of years. We get these ones with children and young people where the COP is authorizing exactly what you can do in terms of holds on them, you know, and it goes into
in a private setting.
Well, so a lot of them end up with bespoke placements, because I mean, in many of these cases, you know, people can't tolerate anyone else being around them. So you end up either building a service around them, which will often be a supported living accommodation, but not a registered care home. So it's a very analogous. I mean, and the COP, I mean, if there is a case to be made as to why it's in the person's best interest, the COP may authorize these things. But I think it is obviously a scenario where they need to be very well persuaded that it's right for someone to lay hands on someone. But the risk to others, that was actually something that was considered a couple of years ago in the COP. And again, there is standing COP case law that if you have people who, for whatever reason, they may commit sexual offenses. I mean, they probably wouldn't be found criminally responsible, et cetera, because the background, but you may commit sexual offenses, may assault people, that it is in their best interest to be kept out of trouble. Because again, it really doesn't do the person any favors to go out and assault someone and then end up in prison or in police custody or something like that. And the COP does take a broad view in terms of what is in the person's best interest. And I think the COP is usually pretty easily persuaded that being arrested by the police is rarely going to be in a person's best interest.
But I mean, that's that, as I say, for this scanty audience here, but thank you all for turning up. That could be a seminar all on its own, just the issue of deprivation of liberty, and I think it should be. I mean, I didn't touch on it in my talk because mine was just a sort of skim over the top of the issues of capacity, but that is something which, with heavy care regimes, but it's for both sides to consider, and it's obviously for deputies to consider and case managers. And it gives rise to some really difficult issues, bearing in mind the deprivation of liberty safeguards only apply to hospitals and registered care homes. Well, you've had your hand up for some time.
Well, I have, but I've been overlooked.
Yeah.
So going back to what Derek was saying about the siloing between personal injury and court protection, and what you're seeing several years down the line after a settlement, and the rise of deprivation of liberty or excessively over provision of care suggests that when we're acting for defendants, defendant lawyers and defendant experts are not being bullish enough about future care claims.
Let me put that in a less inflammatory manner, because bear in mind, I think the first issue, I think, which would apply to either side of the litigation, because once a claimant firm has dealt with the case and it's over, it's no different to a defendant in most ways. Are there any publicly available statistics about the number of general orders being discharged each year? And if so, are they, is it publicly available information in respect of whether those claimants were personal injury claimants?
And not to my knowledge, I don't think the COP puts out any statistics specifically on that point, but I mean, I'm sure that's how I think today.
Well, I mean, it's just, when it's talked by either side's experts, well, this person probably crosses the border now, but it needs to be reviewed in a few years' time, or it needs to be reviewed post-litigation. What one has to ask is, it's such a massively important order, the blunt instrument, isn't it? It is, management of property and financial affairs. There must be claimants and their families who come to recognise the profound limitations on them. And what happens in that circumstance? And is there anyone in the audience who has experience of that, or advising clients, or dealing with it? Once litigation is over, once dust settles, there's so much stress in the process, and it's so involved. Once the dust settles and time starts to pass, and then the post-litigation world becomes the norm, what happens? I don't know. I'm only asking. Perhaps.
But the only thing I would say is that you are allowed to go and get expert evidence from your potential deputy, from your expert, and those are the sort of scenarios I think you've got to be discussing with the deputy when you're going before the court to say this might happen, that might happen, etc.
Yeah, but it's the evidence base for any court to make a decision about the future. I mean, perhaps the more relevant point.
Maybe we'll start having periodic payments, which allow variable periodic payments, allows to go back if there's an increase.
Well, I was going to say, well, that's the next point. So, in a case where there is a capacity issue of the sort that Arianna has discussed in G, but a variable periodical payment it wouldn't relate to improvements.
But that's going to create a nightmare.
It would. Totally.
At the moment, you have this is what. It occurs to me that the reason why that may have happened in that very case is because the deputy who has a periodical payment coming in every year feels obliged to use that payment for the purpose for which it was originally intended.
Arianna said they were overspending as well.
But absolutely, but they were but that periodical payment may not have been necessary on any view to be used for this purpose. But if it's not spent for that, then they think, well, someone's going to come back and say we were overpaid, and that they're going to start opening that up, which will be a real can of worms. If you had a variable periodical payment provision, it would be even worse.
Yeah.
So, I mean, it strikes me that the problem comes from the lack of independent analysis. It's what someone said a moment ago.
Yeah.
Independent analysis of the situation as time goes on. And this is not a capacity or not capacity situation. This is all in the context of lack of capacity, how much is being spent.
Yeah. I mean, and the thing is, but ultimately, that's the post-litigation world that theoretically is nothing to do with us. But actually, from both claimant and defendant side, it is something to do with us.
Yeah.
But what the discussion has shown, and again, you know, people, please add your experience, is it's totally unpredictable what might happen. And I mean, the more interesting cases are obviously the borderline capacity cases. You know, regaining capacity, claimants applying to discharge capacity. I don't know the stats on that, how often it happens, or, you know, in a barn door lack of capacity case, whether things then change, as Arianna was being discussed. And these are all really interesting points. Same with the dolls point. But I think what we were trying to give today was just an overview. And I know I'm going to be accused, particularly by Sadie, of speaking for too long. But in fact, we were supposed to be speaking for an hour and a half in total. So, you know, I hope I'm not too much to blame here, Arianna. But we were, you know, just giving a general guide, and as I say, my slides will be available, yours as well. So if anyone would like them, just frankly, just to have a note, just to even, so you don't have to bother looking at legislation.gov.uk to look at what it says in the Mental Capacity Act, please feel free to have them. I'm not trying to shut down any more questions, apart from Camilla's planted question that she was going to ask, just to get the ball rolling. But are there any, does anyone have any questions? Please feel free to ask. Don't ask about your individual cases, but
Well, there is one other interesting observation from the Q&A, which is to make the point that executive or frontal lobe function cannot totally be captured by any test.
yeah,
The test fundamentally covers cognition, not behaviours or emotion.
wasn't that what I said?
However, it is the function of it to determine the ability to weigh up. And it's an area which this commentator said needs to be discussed more thoroughly in the literature and considered on how it bears on discussion.
Absolutely, yeah, and
Discussion for another time.
exactly. No, I mean, we could have a whole discussion with a neuropsychologist about, you know, the Hailing Island test, the Hailing test, and the Brixton spatial test, and DCAPS about executive functioning. They don't really, do they really tell you a great detail about someone's level of executive functioning? We've all spoken to neuropsychologists who've said, well, you need to know how someone's functioning in the real world. But that was, I mean, I was just glossing over that point, but just to make it quite simple, you know, a significant decline in full-scale IQ, for example, measured neuropsychometrically, is not an automatic cutoff in terms of someone's capacity. It's not that mechanistic. Any other questions, anyone, or have you all had enough? Anyone? No, thanks.
I just had one question to you, Derek. So whether acting for defendant or claimant, situation where interim payments involving a child or whatever, but defendants often say, oh, you don't need to go off and get approval, you know.
You have to get approval.
And claimants, you may well be advising having taken over a case, and you see that there are a number of interim payments
You have to get
which
approval.
haven't been authorised.
Yeah.
Your advice is always that.
Yeah. And this is a matter of general. I mean, if you look at the rules, they even say that a voluntary interim payment has to be approved that's made prior to litigation. So in fact, these are rules that are more honoured in the breach than the observance.
So that's what I mean. It says.
Yeah, and any prudent, I mean, we've all been involved with cases where one of the first orders at the end of a case is the court approves X, Y, and Z. But being sensible, I mean, if there's any interlocutory hearings where you know, applications can be made for approvals ex post facto, then they should be taken. But I mean, it's a safety net, if nothing else, isn't it? Because you want to make sure that the court doesn't criticise an interim payment when it comes to the end of the case and the assessment of damages, if too much has been spent on X, Y, and Z. So no, I thought it's absolutely critical.
Particularly if it's a contrib case.
Absolutely, yeah, absolutely.
Why is that?
Well, you're going to ask something about contributing.
It's contributing, and the effect of a payment will reduce disproportionately the amount at the end of the day.
Yeah. Well, I hope everyone's enjoyed that, and online, if you're still there. I don't know why I'm waving at the camera, but I've enjoyed it. I've enjoyed speaking to you all. I'm sure Arianna as well.